Hey there, it's Peter Sankoff here. If you are interested in learning more about the Supreme Court's groundbreaking decision in JJ and what it means for the defense bar, join me Friday, July 15th. I'll be talking at 11 a.m. Mountain, but of course you can always get a copy of the recording if you're not available. I'll be discussing that case and much more. What's happening with Section 276, myths and stereotypes, and everything related to sexual assault. You can find out more by checking it out and signing up at petersankoff.com. Okay, I'm recording. Hello and welcome to the final episode of the season for Professor Sankoff's Criminal Defense Essentials podcast. And nothing really to talk about today, except for the Supreme Court of Canada's decision and JJ. So I've got a lot of preliminary thoughts, and then I will get into the judgment. So I feel that whenever I start talking about this, I have to do caveats. That's just the way it is. I've got to do some caveats. So I'm going to start with the caveats of I was counsel for the CTLA, which was one of the interveners in the case. And as such, that always affects the extent to which I am willing to speak freely about a judgment. And I say that because while I feel perfectly capable and think it's fair to critique judgments where I did not participate, I'm much less likely to do so when I was counsel in the case, because the reason being, like, I had the chance to make all those arguments and the court didn't buy them, right? And in this particular case, the defense bar as a whole lost pretty resoundingly. The Supreme Court affirmed that Parliament was right and that the advocacy groups suggesting this was no real imposition on the defense were also correct. So, I made arguments about the risks, and a lot of those arguments, if you want to know what they are, just go look at Justice Brown's decision because he encapsulates them. But I don't think it's fair, nor do I think it's really proper for me to just sit here and bash, what the Supreme Court did because I don't agree with it. I mean, it's obvious I don't agree with it. I felt what I argued at the Supreme Court. You can read my factum. It's on the Supreme Court website, but that is not the law. So I am always a little bit more restrained in critique, because quite frankly, I don't want it to be just sour grapes. I don't agree. So what I would rather focus on is just talking about what I think the decision means and perhaps explore some of the implications. Okay. Anyway, so that's my thoughts on sour grapes, and I don't want to be sour grapes when I'm doing this sort of thing. So I'm just not going to do that. I'm just going to tell you that the Supreme Court has made a very clear decision on where things are. And as a result, that is the law. So I'm going to talk more about what I think is going on in the case than I am critiquing it, simply because, as I said, I don't want to get into this sour grapes thing. So let's just talk about it. And I will just say for the record that, believe it or not, I haven't read all the dissenting judgments in the case. I've had a look at Justice Brown's. But, quite frankly, when you're at this point and you've got a 6-3 decision, I don't take much solace in what the other judges have said. The fact that they agreed with the arguments for the defense bar, that's all well and good. But at the end of the day, the judgment, this is the law. And everybody's got to sort of deal with that and get over it. I obviously, again, because I argued against this approach, I don't share the view that that should be the law, but it is the law, and that is where we are. And it's time to sort of cope with that and sort of figure out what it means. So I'm certainly going to focus a lot more today on what it means than how I feel about what it means. Because again, for the reasons I've already set up. Okay, so I'm going to go, if you have the judgment in front of you, you don't need it to listen to this podcast, but I'm certainly going to go through and talk about judgments and what it means. So like, if you had any doubt about where the Supreme Court was going on this, because I honestly didn't know, I wasn't sure what they were going to do. And even when you read the quick result, okay, they uphold the law. Like, I knew that there were a lot of ways they could uphold the law and still, narrow its application. But like, all you have to do is read one or two paragraphs and that this is going to be a resounding loss for the defense, in that the entire the first sentence is that the criminal trial process can be invasive, humiliating, and degrading for victims of sexual offenses, in part because myths and stereotypes continue to haunt the criminal justice system. So I'd say two things about that first line. One is that it sets the tone for where they're going. And two is that it sets really in motion the potential for more law restraining what defendants can do in sexual assault cases. Like, I think that's real, because like the next target is myths and stereotypes. And I don't see why any of this, and I don't really want to give Parliament too many ideas, but I don't see why any of this has to be restricted to records. The way in which the Supreme Court has dealt with this, I believe that personal or private information is going to become like a Section 276 application of its own. And if that sounds far-fetched to you, like, read the judgment. Like, myths and stereotypes are at the core of this, and whether or not like private information or a record, it really doesn't matter, because like at the end of the day, like the record issue is sort of like a red herring, because like the question is where you got the information from and what it actually is used for. And if they're really concerned about myths and stereotypes, I think the legislation is likely to be expanded in years to come to restrict cross-examination, or at the very least put in a hurdle before you can go to any sort of cross-examination that touches on a myth or stereotype. If that sounds frightening to you, I'm just telling you what I see. I'm not here to comment per se, but it says, like, the first paragraph says, more often than not, they could expect to have the minutiae of their lives and character unjustifiably scrutinized, all of which jeopardizes the truth-seeking function of the trial. There you go. So again, what does this mean? It means that the court views most cross-examination that explores aspects of the victim's character, because this is not sexual activity. Keep in mind, sexual activity is in another regime. So essentially anything that goes to character, or perhaps even impeaching credibility, has the potential to jeopardize the truth-seeking function of the trial. There's little recognition that cross-examination on private records can enhance the truth-seeking function of the trial, and that is something of which we'll, I guess, have to disagree. So then the next, then they get into explaining that more needs to be done to change trial procedure. Like I don't know what more to say than that. Like, again, if you think this is the end, you haven't been following. Like, if you think JJ is just bad, you're a defense lawyer and you think it's problematic because of what it entrenches, because now there's this procedure. Like, I just think you haven't seen anything yet. Like, a lot of potential procedures and rights are now in play because the Supreme Court's put them in play. And while they say, no, we're not doing that, no, it doesn't go that far, I think, like, I agree with some of the dissenting judges who say it really does go that far. And I'm not sure what the limitations are, because frankly, like, if more needs to be done, more needs to be done. So like, more is likely to be done, right? Like, that is just the way in which this is. So like, I think that's a realistic, very realistic possibility. Like, what are you going to do about that? So anyway, that's the way it is. So moving right along, they elevate they then go on to talk about the twin myths, and then again make part of like there are other myths we have to deal with, and they make that very clear. And they talk about the way in which this provision works. So then it goes on to the provision. So let me talk about the definition of the provisions and the way in which the court deals with that, because the court decides, for whatever reason, to deal with this as a matter of interpretation first and constitutional argument later. But essentially what they find is the interpretation defines everything, and the constitutional arguments are not that strong or non-existent from what I can see. So anyway, the court, I'm just zipping forward a little bit. So the court starts with this stage one process. Okay. And the stage one process is the process by which an accused person or their lawyer has to put forward detailed particulars of the evidence the accused seeks to adduce. So right off, they say, well, the legislation doesn't specify how the stage one inquiry is to be conducted. It can be in writing, an oral hearing, or both. So essentially, the stage one hearing, the way the Supreme Court has set it up now, has two purposes. One is to define whether or not what the defense has is a private record. That's number one. And number two is to decide whether it's actually worthy of going to a hearing or whether it should be dismissed on its face. Now, both of those things are really, really important. And this is a paragraph 29, if you're keeping track. For private record applications, if the judge determines that the proposed evidence is not a record, the application will terminate. Like, that's right off. The Supreme Court does go on to talk about motion for directions, but realistically, it seems clear to me that they think that the question of whether something is a record is a definable issue for the trial judge at stage one. So let me explain what that means, because that's a lot of legal mumbo jumbo. So one of the problems that's been raised by the defense bar is that, like, when the accused is in possession of private records, and if you want to know what private records are, just, think about text messages, email, like anything that is sent by a complainant to an accused person. Right? That is, all of those things could be construed as private records and private information. That's made very clear in the judgment. So now when the accused gets that information and wants to use it in some way at the trial, there was a real question in the case law. It really wasn't clear whether if the accused thought it was not a private record because it didn't contain sufficiently private information, then they didn't have to go through the regime at all. And that was based on the idea that, generally speaking, the accused doesn't have to disclose anything to the Crown or a complainant. And the problem was that if you make the accused a gatekeeper, it puts the accused in a really tricky position, because they have to make a decision about whether or not to disclose. And if they make the wrong decision, the judge might not admit the evidence at all because it wasn't done in respect to the proper procedure. So prior to JJ, most defense lawyers, like in most provinces where this was struck down, like Alberta, they didn't have to worry about it at all. But previously, defense lawyers were bringing motions for directions, which were like pre-screening hearings. And the Supreme Court seems to suggest those are still possible, but I don't really read it that way. I think by and large, what the Supreme Court is saying is that if there's any doubt, you go into the proceeding, which just expands its scope dramatically. It is very broad now. And I think the accused can still refuse to provide information about something, but if they're wrong and it is private information, and that's a fairly broad term, the trial judge has the grounds to exclude the evidence altogether. It's a very messy procedure. But again, what the Supreme Court seems to be saying is put it in, and that will delight both the Crown and complainants' advocates. Like it really will, because it will be regarded as, positive for them. But for the defense, what it means is even if you have material that you don't think it applies to, you pretty much have to run an application anyway, just to be safe, because that is a pre-screening application part of section 278.1. And the court also makes clear if the judge concludes it's not capable of being admissible, they can exclude it at that stage as well. So that's number one. Part two of the application, which is to determine whether the evidence should be admitted, is really a non-issue. I don't think it's an issue that really worries most defense lawyers. To be honest, I think most applications will succeed. I just think they will, unless they're spurious. The threshold's not that high. The defense should be able to show how the text messages are relevant. And if they can't, I don't know why they're bothering with the procedure anyway. So really, it's just the screening that's the biggest concern to the defense, but those concerns get wiped out by pretty much by this decision. Okay, so how do we know if it's a record? Well, the court says we are supposed to engage, sorry, I had to laugh there, in a complex three-part test. Like every defense lawyer, you get some records, you got to do a three-part test. But of course, what the court says is don't do the test, just file the application anyway. Disclose it all over, because there is, according to the court, we're going to get there, no harm in such disclosure. None whatsoever. I told you I'm not doing detailed commentary, but that's what they say. So is it meant to be exhaustive? Yes. Even if it's not in one of the enumerated categories, we're going to include everything. How do we identify those? Well, the Supreme Court looks like it's being really favorable. Honestly, they're doing a solid to the defense bar. They realize that this could be very broad, but what we're going to do is, are you ready for this? We're just going to make up a new definition for what private information is. And they do that by saying, well, number one, we're going to abandon content neutrality, and we're going to use this new test from some other example in like another area of law that says, well, it depends on whether the informational privacy transcends personal inconvenience by reason of the highly sensitive nature of the information that might be revealed. Now, if you're a defense lawyer, you may say to yourself, well, that's something, right? At least I won't have to disclose innocuous text messages and allow those to be scrutinized on a regular basis. But I don't think that's true either. Because the Supreme Court says that what qualifies for that lengthy made up test that they come up with is it's a three-part test that requires detailed balancing. So I don't see how you can avoid doing this. They point out that we're not going to use content neutrality. Big mistake, in my opinion, because this is very different, right? It's so different that we are not going to do this. Any form of record is captured. Parliament has come up with a new test, so we don't need to worry about state search and seizure, which is content neutral. Now, as an aside, what they decide is that you can have residual expectations of privacy in information that you send to a third party. So if the complainant sends the information to the accused and says, I don't know, I want to come sleep with you or whatever, the court's test says they retain a reasonable expectation of privacy in that information. And the reason for that is kind of interesting. I use interesting because I'm not allowed to say more. Geez, there's so many nuggets in here. They say that because, are you ready for this? That you've got to look at a million things. Why the complainant shared it, what's in it, who they shared it with. Again, I don't know how the defense lawyer is supposed to do this. You just got to throw it all to the judge. But they say that you can do this. I'm just trying to find the paragraph because I think it's really interesting. Here it is, paragraph 62. Okay. Paragraph 62. Justice Cote maintains that complainants have no reasonable expectation of privacy in communications with the accused unless they're in confidential professional relationships. Well, for what it's worth, and it's worth virtually nothing, obviously, I agree entirely with Justice Cote, right? But the court says no. And this is the line that kills me. The fact that they've chosen the wrong person to trust should not be determinative of their privacy interest in the context of alleged sexual violence. Sorry, I'm just taking a breath. I don't know what to say about that. And I say that because I don't know what to say about that. Like, I don't know what to say about that. That's it. Like, it's just, I have no, oh, the paragraph reference 62. So like, right, the reason, let's just say that I have argued for a long time that, like Justice Cote, if you send something to another person, you lose your expectation of privacy in it. I believe that's true. I think that makes sense. I don't see how I can hope that the recipient will keep it private, but I don't see how I can demand that they do so. Now, if there is an overlaying privacy interest, like if I send a text message to my therapist, that's different. But like without that, I think it's too unwieldy to start saying that there are expectations of privacy that go beyond text message when everybody and their mother knows that if I send a text to somebody and say, don't share this, they can talk about it anytime they want. So I don't really get that, but there's apparently a different way of looking at it in the context of alleged sexual violence. So my question is this: if the accused sends a message to the complainant and the complainant wants to disclose that to the police, like, does the accused have an expectation of privacy so that the police needs to search them? And I would say the answer to that, just using the Supreme Court's logic, is no, it's not. They've already said that Section 8 applies differently. And they've also said that this is because of their privacy interests in the context of alleged sexual violence. And if that seems unfair or perhaps even ridiculous to you, we'll have to wait for the Supreme Court to sort it out. Like, I would certainly argue that the police now need to get warrants before they can look at anyone's phone, which I personally think is ridiculous. But I also think what the Supreme Court says in paragraph 62 is, sorry, I'm not allowed to do commentary on this particular case, but that's what they say. So that's what we're living with. We could keep moving on because there's just so much more. Again, then they start talking about the summary of the process, and paragraph 72 is a big one. As I said earlier, when it's unclear if the evidence is a record, err on the side of caution and initiate stage one. To be clear, the accused will know the context in which the evidence arose and will be ready. Like, they're just saying, shove it in. And the reason they want to shove it in is because they don't think there's any harm to doing so. And I can't quibble with that at this moment. They then say the Crown is not bound by this regime. Lucky for the Crown, like, that's good. Although, of course, if the Crown was bound, we just have more pretrial applications. And if there's anything this country needs, it is more pretrial applications. Okay, moving right along, there's some interesting stuff in paragraph 76 and 77 about adducing, because the provisions actually apply to when you adduce the record. Many people have said it should be a narrower interpretation only when you're going to use the evidence and enter it as an exhibit at trial. Supreme Court says no. Get ready for this. Specifically, I'm reading, under the record screening regime, the accused must screen records when they seek to use information during a hearing that they specifically learned from those records. Try to keep up. If they have independent knowledge of the information gathered from sources that do not rely on the complainant's private records, they may use this information without invoking the record screening regime. I don't even know what to say about that. Like, I certainly think I'm going to instruct accused people not to bring text messages with them. And, you know, I suppose so just to be clear, until Parliament adjusts the regime, if the accused knows something because the complainant told them orally, you can cross them on it. Or if they told a friend orally, cross-examine. But if it came from a text or an email, for some reason, that magical protection is gone. I don't get it. I really don't get it. That's all I can say. Okay, moving right along. Then they go on to say, when should you do it? Well, you should do it pre-trial. That I think is logical, by the way. I did not like any of the arguments that said do it mid-trial. It's too messy. It's too cumbersome. I just thought like the law was too broad and shouldn't exist. But if it is going to exist, you've got to do it pre-trial. They make that clear in paragraph 85. They also make it clear if new information occurs, you can raise a new application. Again, more applications. That sounds wonderful. What's the scope of complainant participation? They give the accused a small, I don't know what you want to call it. They do a small bit for the accused. The complainant does not get to participate at stage 1, but get this, if there's a motion for directions, they do get to participate. And that the complainant should be notified of things that are going on. There's just a lot of stuff in here. And it's like, again, it makes sense when you realize that the Supreme Court doesn't find there to be any prejudice whatsoever to the accused from having to make this application. Like that really drives everything. Once they decide that you have no right to remain silent or no, prejudice from making these applications, then everything else sort of flows from that. They do say the complainant can't cross-examine because that was a huge risk. But like, again, once you provide a copy to the application, it should be given to the complainant. So even though they don't get to participate at stage 1, they get notified at stage 1. So all that is just getting ready and ready to go and all this stuff. And then they get to participate, make submissions. We know all that. Are motions for directions permitted? They say sort of, but I don't know. Where in the opinion of the judge, the evidence is clearly a record, deal with the matter summarily and order the accused to proceed. So you can ask for directions if you like, but it doesn't seem to me to make any sense as to why you do that. Complainants don't have appeal rights, no big deal. Then we get to the charter analysis, which is where everything is. So they've essentially set down exactly how it works and how important it is before getting to the charter. So like you can see where this is going to go. They say to begin with that the appropriate methodology for assessing multiple charter breaches is to consider them all. And they also say that, well, before we get into section 7, you've got to consider the rights of the complainant and that you've got to take it from the perspectives of the complainant. That's in paragraphs 119 to 120, because the complainant's privacy, dignity, and equality interests are at play. I just want to say this, and you can take this for what it's worth. Like every time you start measuring section 7 rights through the eyes of the complainant, it just, all it does is dilute the rights of the accused. Whether that's wrong or right depends on your perspective in that. But the idea that we can carve out special rights for the sexual and interests and the dignity of complainants in sexual assault proceedings strikes me as a bit weird. Like, I don't understand why I, as the victim of another offense, like an assault or an assault caused bodily harm, have no dignity or privacy rights. Like, why is that? I mean, I understand sexual assaults are very invasive, but sexual assaults are across a spectrum. And like, why is like murder or attempted murder, why do I have no dignity or privacy? Like, I think I do. And I think victims of fraud who have to delve into how stupid they were being duped or put up their private bank records, like they have privacy interests too. So I just don't see this stopping here. Like, again, once you start to dilute the right, you're willing to dilute the right. And I don't see how you can have different rights in different situations. I certainly don't see how you can have different rights with respect to different crimes. So like, my point is, while the court's trying to distinguish this on the basis of sexual assault, I don't see it. Like, I don't see how they're going to do that effectively down the road. And I think this is just going to lead, I hate to break it to you, to a slippery slope. And the court says, no, that's not true. And they quote Elaine Craig for the proposition that the impact of an intrusion into the privacy of a sexual assault complainant will often be qualitatively worse than a similar breach with respect to the alleged victim of fraud or theft. Like, to me, that's like, yes, sometimes, but sometimes it won't. And sometimes like sometimes those other crimes will be more invasive. And like, I think she's trying to say that collectively they'll be more invasive. Again, like maybe so, but like I can think of a lot of things that are socially constructed as deeply private. Like fraud is a great one, because like fraud is like, depending on the nature of the fraud, like people's finances are very, very private. People don't share that stuff like ever. It's anyway, I don't see it, nor do I see how my bodily integrity is not deeply private, and the injuries I went through in various things, or how it affected me. I don't know. Like I'm just struggling to see how they're going to distinguish this. And my feeling is, like, again, leaving aside whether I agree, let's assume I do agree. Even if I agree, I'm struggling to see how they're going to legally confine this. My feeling is this is just going to lead to more incursions in all areas, but especially in sexual assault, because they've carved out this private special area. So I guess my point is this: if we take the court at its word, expect more in the area of sexual assault. If we take the court as being intellectually dishonest, then expect more everywhere else. That's my feeling. Moving right along, no problem, no problem. Like, to me, the stuff that's really toughest is when the court says things like section 278.92 does not impair fair trial rights. This is just like Darich. Now, if I go more into this, then I am going to get more into the sour grapes area, because these were my arguments. They just equate this to any other type of evidence. And I think that's dangerous, because now once they start saying that, I am struggling to see what the distinguishing factor is. Now, they say the distinguishing factor is that this is sexual assault, but I've already raised that. They say an important similarity between 276 and private records is they both seek to protect complainants against harmful myths and stereotypes. I have to take a deep breath. Like, I don't know what to say about that. Like, any category of evidence as a matter of fact can promote myths and stereotypes. Like, stereotypes are just taking over generalizations from particular points. Like, the control over the stereotype is not really the issue. Like, it's hard for me to accept those ideas that essentially, well, either you can do this or you can't. And they just decide, well, it's not really obtrusive. It'll only be violated if you're preventing from adducing relevant and material evidence. I think you are. I think the section 276 threshold, which makes sense in the context of 276 because of the presumptive irrelevance of the evidence, does not exist here. But I made those arguments at the Supreme Court and lost. So there's not much more I can say about that. Moving right along, then they talk about defense disclosure, which to me was always the biggest problem. And they say that's not a problem whatsoever. We've all misinterpreted the right to silence. They reread a lot of cases that say that, and they reread all those cases. And this is, quite honestly, the part that I think defense counsel need to be aware of. They say that Stinchcomb and Chambers and PMB do not stand for a general rule against defense disclosure. So get ready for more. Get ready for more. I would. They again try to distinguish that by saying, well, is no slippery slope. It's specifically tied to this purpose, but I don't see how you can do that. Like, I don't understand how you can say that. If you start with the idea that there's no right, then any reasonable purpose to remove the non-existent right will be valid. Like, Parliament wants to convict murderers, fraudsters, everybody. Like, why not put screening regimes in? Like, I don't understand where the justification comes from. If you start, like, it's one or the other. Either the proposition doesn't exist, so you can ask the defense to give stuff over, which seems to me to be completely at odds with those cases, or you can do it in certain circumstances. But then, like, what are those circumstances and why are those so special? So, like, I don't understand that. they keep saying that like private records are analogous to section 276 as they can also implicate myths that are insidious and inimical to the truth-seeking function of the trial. Like all evidence can be inimical to the truth-seeking function of the trial. That's just called prejudice. Like any piece of evidence used incorrectly can do that. And I'm willing to accept that there are certain categories of evidence that do that more often than others. But like, that's why we have section 276, because it's recognized that that's a category of record. That's a category of evidence. Like private records are not a category of evidence. They're a type of evidence. And what's in them can be anything from you didn't do it, I know that, to some much less probative piece. And I don't know how that distinction makes any sense. That's it. The part they go on about PMB, I can't even talk about because it's just literally like, I don't know what to say. I don't know what I could say without being mean about it. So at the end of the day, like they don't have any impact. They're not concerned that giving stuff to complainants, they say all it does is give myth-based reasoning. So like they essentially deny any ability or any concerns about the nature of the evidence. So like that there's really not much more to say about the decision. I think, as you can tell from my comments, that the decision has major implications. I don't know exactly what it'll be. I mean, the first and most obvious implication is that this law is now in force across the country. So get ready for your 278 applications. I would add, by the way, that there's one little snippet that's interesting. You don't have to get the affidavit from the accused, and the Supreme Court pretty much suggests you don't do so. And for those of you going, no, the Crown will ask for an affidavit from the accused. This is one area where I think there is a difference between section 276 and section 278. And let me just say to any defense lawyers out there, I would never put forward an affidavit from the accused in these situations unless the court literally orders you to do so. The reason is that section 276 evidence will usually be stuff the accused knows, and it has to relate directly to the accused's evidence and what their defenses are likely to be. But section 278 evidence doesn't work that way. Private records are more likely to bear on the complainant's credibility, or you'll have an ability to make that comparison. So nobody wants to give it up, but that ship has sailed. Let's say that you are dealing with I lost my train of thought. Okay, so you have an affidavit, you have to put forward the basic for the idea that the evidence is relevant. Well, if you have the complainant statement to police and you have the text message that is at odds with it or suggests a motive, you don't need the accused to put the affidavit in. Like, you can put anyone. I'm assuming legal assistants are going to write more affidavits, because like the legal assistant can say, I've looked at the disclosure and I've looked at the text message and I believe it could impact on X. And that's it. Put it before the court. And the reason you want to do that is because you don't really want the accused cross-examined, because the status of that cross-examination and the status of the accused affidavit is still in flux. I will say that I don't think this case definitively defines whether or not the accused can be cross-examined on a section 13 affidavit. And I'm going to continue to argue that they can't, but like that ship is not looking good either. So if I were you, I would avoid putting these affidavits in from the defense where you can. So that's where we are. As you can tell, it's a bit of a somber day. I mean, I never like losing an argument anyway. So like I would be upset even if this didn't have impact on the accused. But I, again, congratulate all the advocates. Crown attorneys are going to be very happy today, and they believe in their cause, and that's perfectly fair. I think the other advocacy organizations are going to be also delighted. And I think Parliament should get to work or start thinking about more laws, because the Supreme Court has really invited them to do that sort of stuff. Okay, I've gone on for a bit, so I'm going to take a couple of questions. Ryan asks, would text messages be private records if they're gathered from a third-party service provider? No doubt. Like, no doubt. It doesn't matter where you get it from. it would be potentially a private record, depending on whether or not the context of the information provides enough indication that privacy should be maintained. In the US, they can get things like that without a warrant. Well, to be honest, it's very difficult to see at the moment how this decision will affect state interests versus the accused. It's really hard. And I say that because they say very clearly at multiple junctures that this does not necessarily apply to state interaction with the accused. So I just don't know the answer to that. And that is something we will have to see as time goes on. So yeah, that's longer than I like to go generally in these sessions. So I'm just going to say to everybody, thanks so much. We're going on hiatus until the fall, at least with the show. So thanks for showing up. And we have a seminar on this, an upcoming seminar where I will dissect the law in much more painful, from the defense perspective, detail. Oh, I have another question. What do I make of the difference between a record and evidence that the accused may want to lead of a particular conversation? Text messages have some objectable badge of reasonableness, where a conversation is harder to prove. So, like, I don't know what to take from this because this whole thing is so weird. Like, it seems to suggest to me that if the accused has independent verification, then the private record is not a private record. So, for example, let's say the accused gets a text message, okay, and then follows up on the text message in person, or better yet, talks in person first and then gets a text message based on that conversation. Like, in the Supreme Court's world, that would not seem to be a private record. And then you can use the text message because it's not independent, it's not the source of your information. Like, I just think all of that is kind of crazy. And when you say text messages have an objective badge of reasonableness, let me just say this, like, text messages are never admissible in and of themselves. Like, defense lawyers think they are, but they're usually not. Text messages can only provide generally the basis for cross-examination, because if the witness is on the stand, then the text message is either a prior consistent statement or hearsay, depending on what you're using it for. It's one or the other. So, like, at the end of the day, like, you've got to put the text message to the complainant, and once they agree that they said X, Y, or Z, the text message has no relevance in and of itself because the evidence of the witness admits that it happened. So, like, the text messages were never about being admitted on their own. There was a question of whether you could use them. And what you're saying is they have an objective badge of reasonableness. Well, what you mean is an objective badge of accuracy, because they actually can show what the complainant said. Well, like, to me, none of that matters. Like, for the question of, are you going to disclose it before trial? The question is whether you need it or whether you plan to rely on it. And that answers your question. If you do, because you think that the complainant's going to try to weasel out of it, even though you have independent information, because that's what's going to happen. As soon as you start to cross-examine on a text, the Crown will object and say you didn't bring a 278. And then your answer, I suppose, is, well, my client had a conversation. The text was only based on that conversation. Like, I just think I don't think that distinction is going to work in practice. I read Daniel Brown's blog and he seems pretty interested in that. I'm just struggling with it. Like, I am. Like, I guess you can get information, but the question is how you contradict on that information if the complainant weasels out of it, and as well, the question of how you respond when the Crown objects and says you didn't bring a 278 application. Like, according to the Supreme Court, if you have independent evidence but I don't know. I think it's going to be messy. All right. I will be talking about this, as I said, in more depth in a couple of weeks' time. For now, the rest of us will digest and be somber about what we're seeing. But either way, we will come to deal with it. In any event, that's all I've got for now. Have a great day, everybody.